5 seconds to go. Start. At the relevant stage, the appellant applied for discharge under section 239 of the CRPC, which should have been under section 227 before the Court of Special Judge Vigilance, Patna, alleging that there were glaring errors in the calculation. Stop. However, the court summarily dismissed the application by its order dated 28th March 2016, without analyzing or examining the documents produced and the arguments advanced. Stop. The court held that para peruse the record, and I find that there is sufficient materials against the accused in this case, at least prima facie at this stage, to frame charge against the accused against whom there is allegation that he during the check period amassed. Stop. Although certain explanations have been advanced by the learned counsel for the petitioner, but the same appears to be looked into and appreciated during the course of trial when the accused petitioner wife have a chance to prevent innocence producing his oral or documentary evidences. Stop. For the present, I am not satisfied with the explanation so produced by the accused in his favor in support of his discharge application. Stop. Para. Considering the aforesaid facts and circumstances, the charge petition of the accused petitioner, namely Kanchan Kumar, is hereby rejected. Stop. Put up on 22nd April 2016 for framing of charge. Stop. The accused is directed to remaining physical present on the date so fixed by this court for framing of charge. Stop. Para. Aggrieved by the dismissal of his application for discharge, the appellant moved the High Court. Stop. After recounting the chronology of events, the High Court proceeded to quote judgment after judgment, and finally dismissed the revision application by merely holding that, para, in the aforesaid circumstances, even if considering the submissions made on behalf of the petitioner, for argument's sake, needs proper verification, attracting roving inquiry, which could be permissible only during course of trial. Stop. Para. Much emphasis has been laid at the end of the petitioner relating to valuation. Stop. With the cost of repetition, the contention of the petitioner is that as the raid was conducted on 21st February 2000, on account thereof, the valuation having been shown against the article so seized at the end of the vigilance must be considered to be in consonance with the date of recovery. Stop. That argument happens to be fallacious in the background of the fact that from the case diary it is evident that valuation has been estimated only. Stop. There happens to be complete absence of prima facie material whereupon one could infer that the value so affixed at that very moment was prevailing rate on the alleged date of seizure. Stop. Furthermore, to ascertain genuineness on this score will again attract roving inquiry, which for the present stage is found forbidden. Stop. Para. Consequent thereupon, the instant petition is found devoid of merit and is, accordingly, rejected. Stop. Para. It is against the aforesaid order that the appellant has approached this court. Stop. Para. The learned senior counsel Shri Sunil Kumar had submitted that the basic objection relating to the calculation and wrongful inclusion of certain items was sufficient for the trial court to discharge the appellant. Stop. In a simple and straightforward submission, he took us through certain glaring errors that were evident from the record of the case. Stop.